This case provides a legal footnote to a 1986 tragedy where two boys, James Annetts, aged 16, and Simon Amos, aged 17, went to a very remote cattle station in Central Australia as apprentice jackaroos. They had each returned to the homestead after spending a week separately performing maintenance on boreholes. For reasons unknown, they drove off into the desert together. Their car broke down. They trekked 18 kilometres before giving up hope. Simon Amos died from a self-inflicted gunshot wound to the head. James Annetts died from dehydration after scratching a haunting message into the top of an empty water bottle. James, my fault. I always love you, Mum and Dad, Jason, Michelle, Joanne. On the handle was written, I found peace. An inquest was held to determine the causes and circumstances of their deaths. The parents of the boys were represented by barristers who were permitted under the relevant legislation to cross-examine witnesses. At the end of the inquest, they asked to make closing addresses. The coroner refused on the basis that he had a discretion whether to allow such addresses or not, and he did not feel they would assist. The Annetts family challenged this on the grounds of procedural fairness. They said that the family of the deceased had a sufficient interest in the decision that they should be afforded procedural fairness, which they said meant the right to address the court on the entire body of evidence. The appeal ended up in the High Court, which split 3-2, but the two dissenting judges dissented on technicalities, not on the question of natural justice. The court accepted that the parents had a sufficient interest in their own reputation and that of their son, that they should have been allowed to address the coroner, but only if the coroner was contemplating making a finding which would diminish their reputations, and only on that specific question. Justice Brennan said, the duty to accord natural justice applies to the class of persons against whom a coroner may contemplate making an unfavourable finding, who alone are entitled to insist on being heard by addressing a submission that the unfavourable finding should not be made. From this case, we learn that in limited and rare circumstances, the entitlement to procedural fairness may in fact extend to people other than the person immediately affected by a decision.